Good afternoon. Good to see so many familiar faces and some new faces and guests from around the way. Welcome to the McFarland Hubbard House, headquarters of the West Virginia Humanities Council, for the fourth in our 2022 Little Lectures series. This year's series, supported by the National Endowment for the Humanities initiative, A More Perfect Union, aims to explore issues of civic engagement and civics education as part of a series of programs leading up to the 250th anniversary of the founding of the United States. 2022 marks the centennial of the 1922 Charlestown treason trials that followed the famous Battle of Blair Mountain, during which approximately 10,000 armed West Virginian coal miners fought a three-day battle in Logan County to free fellow miners who had been imprisoned under martial law. Over 500 miners and their allies were indicted in a series of trials that became a major test of free speech for the American labor movement. Today's little lecture discusses the legal and jurisprudential impact of the Charlestown treason trials and how many of the issues surrounding them remain relevant a century later. We're delighted today to host Dr. Rachel Donaldson, a historian and historic preservationist whose work focuses on cultural and labor history. Among several other book and journal publications, she is the author of I Hear America Singing, Folk Music and National Identity, and the co-author of Roots of the Revival, Folk Music in the United States and Great Britain in the 1950s. Educated at the University of Maryland College Park, Fordham University, and Vanderbilt University, she has turned recently to place-based approaches to labor history. Dr. Donaldson has worked for the National Historic Landmarks Program of the National Park Service, during which time she revised and contributed to the Park Service's Labor History Theme Study, an extensive document that, among its many other uses, helps guide and assist applicants to the National Historic Landmarks Program develop proposals for site recognition. Dr. Donaldson herself co-authored an NHL nomination for the Jefferson County Courthouse for its association with the legal aftermath of the West Virginia Mine Wars. Until recently, Dr. Donaldson was associate professor at the College of Charleston in South Carolina. However, this month, congratulations, she relocated to Maryland to take a new position as curator of collections and exhibitions at the Baltimore Museum of Industry. Please join us in welcoming Dr. Rachel Donaldson.
Well, thank you all for coming. I'm going to try to give a little bit of a nutshell, but a very big one, of the mine wars and focusing particularly on the issues of civil liberties. So the term mine wars is not uniquely applicable to West Virginia. During the late 19th through early 20th centuries, there were mine wars in the anthracite region of Pennsylvania and the coal region of Colorado as well. In each case, these wars were the result of miners' attempts to unionize and coal operators' efforts to thwart unionization. These struggles were not restricted to workers and work sites, however, but rather encompassed and victimized whole families and whole communities. While these wars were not unique to a particular state or region in the country, they were unique to a particular industry, mining. Although the mine wars in the bituminous region of southern West Virginia were not in and of themselves unique, there were aspects of these struggles that certainly were particular and unprecedented in the larger history of the labor movement, specifically the long struggle to organize miners. Furthermore, the legal aftermath of the wars, the treason trials that took place at the Jefferson County Courthouse during the spring and summer of 1922, captured national attention not just for the legal issues they involved, but also for the impact that the verdicts could have had on the labor movement in the U.S. as a whole. Even though the legal issue at the center of the trial was whether the defendants, all of whom were labor activists or miners, had committed treason against the state, sympathizers for the defendants saw the verdicts as determining whether or not working-class citizens had the right to protest unjust conditions in the state of West Virginia. It should be of no surprise that conditions for American workers during the explosive growth of industry in the late 19th through the early 20th centuries was difficult, to put it mildly. But extractive workers had it especially hard, especially those who worked in underground mines. One of the miners' main grievances was the exorbitantly high rate of injuries and deaths on the job. During the early 20th century, 1,160 miners died on average from roof collapses, explosions, and fires every year. In southern West Virginia, a region that was growing rapidly, spurred by the demand for the smokeless bituminous coal located there, mine safety laws were the weakest in the country, and what laws did exist lacked provisions to ensure compliance. Despite public outcries that followed in the wake of large-scale disasters, such as 2 explosions that occurred at the Red Ash Mine alone in 1900 and 1905, the state legislature refused to pass new safety regulations. In 1901, the governor even stated, and I quote, "It is but the natural course of mining events that men should be injured or killed by accidents." But maybe if operators took any measures to protect workers, like hosing down walls to slow the spread of fires, these accidents would have been far less frequent. Another major complaint that West Virginia miners had centered on the living conditions in company towns. Because mining operations were set up in regions that often lacked nearby towns, coal operators had to erect housing and facilities to both attract and maintain a steady workforce. While we think of company towns as common to coal mining in general, with residents owing their soul to the company store, this was not necessarily the case. According to a federal study in 1924, in the coal regions of Indiana and Illinois, only 9% of miners lived in company-owned towns, whereas in West Virginia, 80% did. So that's a big discrepancy. Not only that, but the degree of control coal operators had over the miners and their families in these company towns was exponentially higher than in other coal regions. As unincorporated municipalities controlled entirely by the company, residents could not elect officials or have any real say in the governance of their communities. In addition to owning the homes, schools, churches, and such, operators controlled all land except for any creeks and railroad tracks. This meant that company heads were able to control not only all that happened inside the towns, but also all entryways and exits to and from town. This alone would have profound consequences for miners and labor organizers during the mine wars. Perhaps the most visible symbol the power operators had over the workforce was the company store, oftentimes the only place where miners and their families could purchase necessary goods. Prices in the company stores were often higher than in independent towns, and operators frequently turned to price gouging to make up for lost profits when the price of coal dropped. And so the issue of being forced to buy in company towns is going to be one of the key issues during the first stages of the mine wars. But this was not even the worst of it. Another major grievance miners and their families had about living in company towns centered on how they were policed. In reality, deputy sheriffs were private guards that mine owners hired to protect their property, a job that often led to spying on miners and anyone who came into the town to root out potential agitators, such as, really, labor organizers. Violence and political repression had been common in the mines, but became especially severe after operators began hiring guards from the notorious Baldwin Felts detective agency, specifically to thwart unionization attempts. Tom Felts, the head of the agency, viewed their work as, quote, protecting the operators against organized labor. This involved suppressing free speech and free assembly by prohibiting groups of more than 3 miners from gathering at night because the talk could lead to unionism. Their work was not restricted to organizers. If a worker was suspected of even just being sympathetic towards labor organizing, particularly during a period of a strike, he could be beaten and cast out of town along with his family. Despite the iron grip operators had on the coal region in West Virginia, workers did rise up to protest their conditions and to gain some degree of leverage over their lives. In 1895, the Pocahontas Field, located in Mercer and McDowell counties, along with Tazewell County, Virginia, workers initiated a wildcat strike. And a wildcat strike is when workers take it upon themselves to engage in a work stoppage. It's not sanctioned by a union. This effort caught the attention of the United Mine Workers, which had been organizing miners in the anthracite region of Pennsylvania. 2 anthracite strikes, one in 1897 and a more famous one from 1902, led to the organization of large groups of miners, but not in West Virginia. The non-unionized coal fields of the state were a problem for the United Mine Workers because of the pay discrepancies between unionized and non-unionized miners. The union had been able to win some concessions in the coal fields of Pennsylvania, including primarily a pay increase. But the higher cost of labor now meant a higher price for coal coming out of Pennsylvania. So that meant that coal operators in West Virginia, because they had lower labor costs, could supply their coal at a lower cost. So this is why the UMW had to organize across regions. They had to organize the industry as a whole, not just mines in one area or another. So this opened up the opportunity for West Virginia operators to undercut the prices of northern fields. And lower wages translated to lower prices for the coal. In fact, West Virginian operators fiercely resisted unionization precisely because they relied on low labor costs to gain an edge in a fiercely competitive market. So keep this in mind when we talk about congressional investigations, because once we have the congressional investigations that we'll start, we'll get to it in a minute, think about where they're coming from. And they're coming from these northern areas that are unionized. So let's now turn to the wars themselves. The West Virginia Mine Wars refers roughly to the years between 1913 and 1921. Although efforts to unionize miners did not begin then, this was a period of heightened activity that resulted in unprecedented violence and suppression on the part of operators to shut these efforts down. When operators in the Paint Creek Valley of Kanawha County steadfastly refused to grant union workers a modest pay raise that was on par with what other regional companies had given to their employees, thousands of non-union miners went on strike in 1912, a work stoppage that soon spread to nearby Cabin Creek, when 7,500 miners joined the Wildcat strike. The Paint Creek Cabin Creek strike turned into a 13-month-long struggle that was then one of the country's longest and deadliest labor conflicts, according to historian David Corbin, resulting in the death of 12 strikers and 13 company men. Importantly, as Corbin notes, it was a struggle that brought together a degree of white, black, and immigrant miners to gain union recognition. And, my favorite fun fact, served as the inspiration for Ralph Chapman's famous union anthem, Solidarity Forever. Ralph Chaplin. The United Mine Workers, which supported the strike, even sent veteran organizers, including Mary Mother Jones, who would play an important role throughout the mine wars. The operators responded by evicting whole families, importing strikebreakers from the north and south, and hiring 300 Baldwin Felts guards to bust the strike. The guards constructed iron and concrete forts outfitted with machine guns throughout the strike zone. The violence reached an unprecedented level when the guards drove what was called the Bull Moose Special, an ironclad train car that held several machine guns, through Holly Grove, a tent colony the UMW had established for striking miners and their families, firing at random. An Italian miner, Francesco Stepp, was shot in the face and killed while trying to protect his wife. The news of the train made national headlines the following day, enraging one merchant to the point where he sent cases of Smithfield rifles and 10,000 rounds of ammunition to the strikers. Public intellectual Walter Lippmann wrote of the affair in the New Republic, citing it as the reason why workers should use guerrilla tactics in the war industrialists were waging against unionism. So that's one of the other things about the mine wars, is that it gets a lot of attention from government officials and also a lot of public intellectuals of the time. Now, shortly thereafter, the governor declared martial law, dispatching the state militia to the strike zone. Although the miners initially welcomed the militia members, believing that they would restore peace, it soon became clear that the militia was there solely to break the strike and to further suppress miner civil liberties. In no other place and at no other time in U.S. history had martial law been executed on the scale that it was in West Virginia from 1912 to 1913. Without warrants, the soldiers arrested 200 strikers and strike leaders, including Mother Jones, imprisoned them, and tried them before military tribunals for inciting violence, even though regular courts were still in session. And the treatment was unilateral. The guards and coal operators faced no consequences for their role in the violence. Governor Glasscock's execution of martial law was condemned across the country, and it even failed to end the strike. But this did not stop Governor Hatfield, who was elected into office in the midst of the strike, from going even further than his predecessor by extending martial law beyond the strike zone, testing the limits of what the public would accept. When the governor dispatched state militiamen to destroy the presses and arrest the editors of two socialist newspapers in Huntington and Charleston that had advocated for the continuation of the strike, the U.S. Senate entered the fray to investigate the conditions in the strike region. Indiana Senator John Curran had been calling for an investigation into the state's actions in West Virginia, but he was a lone voice crying in the wilderness. Although the rest of the Senate initially ignored his request, the governor's suppression of the newspapers convinced enough senators to pass Kern's resolution in 1913, initiating a series of hearings lasting months. In the end, Senate investigators issued a report in which they blamed the coal operators and state militia for suspending due process of law that had effectively denied the miners civil liberties, and they concluded that the state's actions had violated the U.S. Constitution as well as the state's own constitution. It also revealed the governor's abuse of martial law, thus preventing him from reinstating it. Faced with this impasse, Hatfield forced a settlement in which miners won the rights to a 9-hour workday, to shop at independent stores, and to elect their own checkweighman. And I could explain some of these after if anybody has any questions about the kinds of demands that were common in strikes of this kind, because checkweighman was a big one. So the stakes of the Paint Creek Cabins Creek strike were so high that Samuel Gompers, president of the American Federation of Labor, made the claim that the strike was a victory, not just for the United Mine Workers, which is an AFL affiliate, but for all organized labor in the country. However, this was not the end of the struggle. The miners' strongest grievance was against the employment of the Baldwin-Felts agents, and Hatfield's sentiment did nothing to fix this. Arthur Gleason, a contemporary observer of the mine wars, articulated this as the miners' primary complaint in his article, Private Ownership of Public Officials. And I quote, "The coal operators maintain on their payrolls public officials who preserve order, guards who keep union men out of the county. It is this exercise of public power under private pay which is one of the fundamental causes and is the most lively occasion of bad blood between owners and workers," end quote. Even in non-company-owned towns, operators continued to maintain ultimate control by paying off deputy sheriffs appointed by the county court. In Logan County, coal operators hired from within, paying County Sheriff Don Chafin, remember this name, and his deputies directly for their services. Chafin alone received a monthly sum of $2,725 from the Logan County Coal Operators Association. While the Paint Creek Cabin Creek strike gained national attention, the events would pale in comparison to those in the coal counties of Logan, Mingo, and McDowell in the aftermath of the First World War. The demand for coal exploded during World War I, and the necessity of it to fuel the war effort led the government to oversee the industry to the point of virtually controlling it. With the federal check on coal operators, membership in the United Mine Workers exploded during the World War years, including in West Virginia. District 17 itself grew from 7,000 members in 1917 to 50,000 members by the end of the war. One characteristic of the West Virginia locals that helped in this growth was its status as one of the few interracial unions. The two locals in West Virginia coal region, District 17 and 29, welcomed black members. The war years were a boom for the coal industry, but the high demand was not sustainable in peacetime. And this is a problem that hurt many sectors of the American industry. After the war, a recession lasting from 1920 to 1921 gripped the nation, with the coal industry especially hard hit. After the war, there was a surge of strikes, again, across industry, with workers protesting widespread wage cuts and the return of corporations' familiar union-busting tactics. And this is actually interesting because the same thing happened after World War II. World War II was the largest strike wave from 1945 to 1946, again, in response to the sudden cut in demand. The strikes that the miners resumed in the coal fields of West Virginia in 1920 and the reprisals they faced bore many similarities to those of other workers during this era. What was exceptional, according to historian John Williams, quote, was the ferocity of the struggle and the character of the violence that ensued, end quote. During the spring and summer of 1920, the organizers of UMW District 17 renewed their efforts to organize miners in the southern non-union coal fields and were able to convince 85% of the workforce to sign the union pledge. While operators refused to recognize the union, the Red Jacket Mine superintendent took it a step further by forcing miners to sign anti-union contracts that may, and these are often known as yellow dog contracts, saying that if you're going to work there, you have to sign that you will not join a union. And this is a move that other operators soon followed. Those who refused to sign the contracts were fired, and operators again hired Baldwin-Felts agents to evict families from company housing. After losing their homes, many strikers' families relocated to a tent colony near Lick Creek. They struggled tremendously during the winter, living on frozen ground and with children getting sick and some dying of pneumonia. Perhaps because of these conditions, the national media again covered the strike in Mingo County, with public opinion being decidedly against the coal operators and state officials. In the midst of the strike, Ephraim Morgan was elected as the new governor of West Virginia. Despite the change in leadership, the status quo of the state government catering to coal interests continued. No real surprise given that coal companies contributed over $750,000 towards his campaign. Now, it is important to note, however, that not all local officials and law enforcement bowed to the pressure of coal barons and Baldwin Felt's henchmen. For instance, and many of you will be familiar with this, in the independent town of Matewan, local officials directly challenged Baldwin Felt agents for evicting families from company housing and destroying their furniture in the process, without legal authority. When local sheriff Sid Hatfield and the mayor of Matewan, Cable Testerman, asked the Baldwin Fets agents to produce warrants, the detectives falsely claimed that they had a court order allowing them to execute the evictions. When the detectives returned to Matewan later that day, the tensions boiled over between Hatfield and Albert Felts, each claiming that they had a right to arrest the other. The verbal altercation turned violent when somebody began shooting. By the end of the shootout, Testerman, 7 Baldwin Felts agents, including Albert and Lee Felts, brothers of agency head Tom Felts, and 2 other townspeople were dead in an event that led to the county's moniker, Bloody Mingo. The Matewan Massacre, as it became known, only added fuel to the fire of the regional labor struggle. By that July, over 90% of miners in Mingo County had pledged the Union oath. Meanwhile, the violence had escalated to such an extent that now Governor Morgan took his turn in declaring martial law, taking power away from the local sheriff and giving it to the state police. Free speech and free assembly were suppressed, and the police had the authority to arrest anyone on any suspicion and hold them in jail. In a contrast to the strike of 1912, Governor Morgan did leave the local courts in session, an action that historian James Green argues, and I quote, and I love this, was no more than a fig leaf to cover up the action of a military regime that would now rule over Mingo County, end quote. Because the restrictions of martial law only applied to the striking miners. Operators received a substantial legal victory when a U.S. District Court judge issued a sweeping injunction that essentially barred the union from operating or recruiting anywhere near company property. The Red Jacket injunction, as it became known, was such that it effectively banned the union from the strike zone. Roger Baldwin, who was the head of the nascent American Civil Liberties Union, the ACLU, discussed even the possibility of filing a test case to challenge this. And I'm going to come back to this story of the Red Jacket injunction, because it doesn't go away. Now, once again, the actions in West Virginia caught the attention of members of Congress, and on July 14, 1921, the Committee on Education and Labor began a series of hearings. Morgan even received a state Supreme Court decision nullifying his use of martial law during peacetime. Undeterred, he then issued a new proclamation that entrusted 100 local residents who had been enrolled in a new unit of the National Guard with the power to arrest minors for any kind of violation of martial law and hold them without charges, without access to legal counsel, and without the possibility of bail, an action that infuriated civil liberties advocates. August proved to be perhaps the most critical month of the Mingo County strike. After the shootout in Matewan, Sheriff Sid Hatfield and Deputy Sheriff Ed Chambers were brought to trial for their roles in the affair. On August 1st, while walking on the steps in the McDowell County Courthouse with their wives, C.E. Lively and another Baldwin Felts agent shot Hatfield and Chambers to death in full view of anyone in the general vicinity. The incident became another rallying cry for angry miners who were growing in number. At a mass meeting on August 7th, the union miners crafted a list of demands to the governor in which they articulated what was wrong with the status quo and how they sought to fix it. In the demands, they state, quote, "Whereas it is known of all men that the enforcement of laws is not now in the hands of the elected officers of the people in said mining districts," end quote, before listing the various rights listed in the Bill of Rights that were being suppressed. The 3-page statement concludes by summarizing the state of affairs in the coal region. Quote, "There can never be industrial peace in West Virginia so long as the great corporations and landholding companies who are not interested in West Virginia's tomorrow attempt to rule with the iron rod through private detective agencies and privately paid deputy sheriffs, who subvert the power that is justly lodged in the hands of the officers elected by a government of the people, by the people, for the people." But on August 17th, Morgan issued a statement in which he steadfastly refused to lift martial law, release any of the union miners from the Mingo jail, or even comment on the murders of Hatfield and Chambers, let alone take any action against the Baldwin Felts agents. If that wasn't enough, he then publicly absolved the mine owners, the state troopers, and the private guards of any wrongdoing, according to historian James Green. Shortly after the governor made his announcement regarding his intentions to maintain martial law in Mingo County, Union miners started to gather in the small town of Marmet, 8 miles south of Charleston. Collectively, they decided to march into Mingo County. The purpose of the march was to forcibly free the striking miners who had been arrested under martial law that was imposed in Mingo. And they first would go to Logan County with the intention of getting rid, maybe killing, Don Chafin, the sheriff who had the separate salary paid by coal operators. But the ultimate goal was to end the mine guard system once and for all, and of course to unionize southern counties. Now, Governor Morgan knew that the bloodshed would be heavy if miners were able to march into Logan, but the state police had been dispatched to Mingo County, and the National Guard was under the control of the Army, so he petitioned the government to send in federal troops. When the Secretary of War declined his request, he went to Sheriff Chafin to have him assemble a home guard to repel the marchers. By the end of August, the miners encamped in the town of Blair, just below Blair Mountain, along ridge line that they would need to cross to reach Logan County. Chafin's army took up its own positions along the ridge line, and it was here that the two forces would come face to face in what was known as the Battle of Blair Mountain, which lasted 3 days. The fighting ended after the federal government dispatched 2,500 troops. The miners surrendered to federal troops because they were not rebelling against constituted authority. Only local and state governments, officials that catered exclusively to the mining interests, to the point of denying citizens their constitutional rights. In fact, miners viewed the intervention of the military as a victory, seeing it as a signal that the rule of law would return to the region, even though they did not succeed in freeing them jailed miners or ridding Logan County of its sheriff. While many historical accounts of the West Virginia Mine Wars cite the Battle of Blair Mountain as the end, this event did not mark the end of the miners' fight. Rather, the final battles were fought in courtrooms, the primary one being in agrarian Jefferson County. After the march, Governor Morgan sought federal charges against the Union miners. The federal government, however, declined to bring charges, instead choosing to continue the Senate investigation into the conditions of the coal region. When the government ignored his wishes, Morgan had the state of West Virginia take up the mantle of prosecuting the marchers. During the winter and spring of 1922, over 500 miners were indicted on charges of murder, conspiracy to commit murder, accessory to murder, and, most importantly, treason against the state. 75 of the more renowned participants were held without bail in Logan County Jail until their trial. Now, while there were numerous indictments, the charge that received the most attention was that of treason against the state of West Virginia, which was leveled against 20 members of District 17. Heavily covered by major newspapers, with articles and editorials syndicated around the country, the charges and the ensuing trials sparked a national conversation on the efficacy and constitutionality of the coal operators' efforts to thwart unionization. The stakes of these trials were high, not just for the workers in the state, but also for the struggling labor movement as a whole. And the labor movement was really struggling by this time. A writer for the Brooklyn Daily Times informed its readers of these stakes at the outset of the trial. Quote, "Beneath the murder and treason charges is a fight of broader consequences to this state and to the nation as a whole. It is a life and death struggle between capital and unionism," end quote. The key fear among labor leaders was that if the prosecution prevailed, the anti-union tactics revealed by these trials would be legitimized and could spread to other industries in regions far beyond the border of West Virginia. From the outset, the charges of treason, which everyone was really following, appeared to be on shaky legal ground. Believing that the charges were improper, the prosecutor for Jefferson County, John T. Porterfield, recused himself and declared that the trials as a whole were a, quote, "waste of scarce resources and mean-spirited vendettas." Into his place stepped C.W. Ossington and A.M. Belcher, whom the miners called the Coal Dust Twins, to lead the prosecution. Belcher had previously been a United Mine Workers lawyer defending miners during the military court trials of the Pink Creek Cabin Creek strike, but had since switched to the coal operator side. The funding for both the defense and the prosecution illustrates the wider issues that undergirded the mine wars. While organized labor paid for the legal defense of the accused miners, the coal operators supplied the immediate funding for the prosecution, although they would later bill the state over $125,000 in legal fees. For the duration of the trials, the prosecuting attorney for Jefferson County and the state attorney general did not participate. As such, in the eyes of many observers, the state was, again, ceding its authority to the coal barons. On April 24, 1922, the trial of the first defendant, Bill Blizzard, charged with treason against the state, began. By most accounts, Blizzard was the leader of the march. Bowden Sparks, a writer for Leslie's Journal, even went so far as to claim, quote, "If there is a king in Boone County, I should say it was Bill Blizzard." But the question being disputed at his trial was whether or not he was at the helm when marchers reached Blair Mountain. Throughout the trial, witnesses for the prosecution and the defense presented conflicting testimony. Although the defense tried and failed to get the charges dropped, they did succeed in winning a motion that forced the prosecution to specifically reveal the evidence it had against Blizzard. Furthermore, according to the New York Times, the judge warned the prosecution that they would lose, quote, unless they could more correctly identify the local union officials alleged to have helped Blizzard and his co-conspirators in financing the miners' army to levy war against the state. This issue was particularly important because the prosecution had the burden of proving that the miners had engaged in acts of war against the state. Based on the wording of the state constitution, which is modeled on the federal constitution, to be found guilty of treason, the defendant must have been involved in an actual levying of war. The sheer amount of media attention given to the treason trials, particularly Bill Blizzard's trial, turned these regional issues into a national conversation. Reactions among newspaper outlets varied to a degree. More conservative papers like the New York Times tended to be on side of the prosecution, whereas others, especially labor papers, almost wholly supported the defense, given the state of local conditions. For instance, an article in the Newark News explained, quote, participants in an armed rebellion should face punishment, but those who marched claimed the desire to liberate the slaves of the non-union coal regions from a rule which has no place in free America, end quote. The writer continues to speculate whether the march would have ever happened, quote, had there not been reasonable ground that the state government was allied with coal operators. The Norfolk Virginian also cast doubt on the charges of treason. Quote, no one believes that even the guiltiest parties were guilty of intent to overthrow the state, a belief in which the New York Evening Post agreed. Almost every paper, including the New York Times, agreed that the state had overstepped in charging the miners with treason. Aside from the defendants, most of whom had the most to win or lose depending on the verdicts, the UMW had the most at stake in the outcomes of the trials, as evidenced by the presence of John Lewis, the president of the United Mine Workers, who attended Blizzard's trial and sat at the defense table rather than in the audience. The trial, which lasted over 4 weeks, ended in acquittal. After the verdict came down on May 25th, miners and local sympathizers celebrated in Charlestown. Later, sympathizers in Charleston celebrated Blizzard with a parade in which he was the guest of honor. Rather than simply exonerate Blizzard, some contemporary observers claimed that the verdict had deeper implications. As a writer for an article published in the Duluth Herald commented, quote, in a large measure, the state of West Virginia was on trial in the Blizzard case, and the verdict of acquittal as to Blizzard was equivalent to a verdict of guilty against the state. But this was only the first, not the last trial. The second and third trials at the Jefferson County Courthouse in the summer of 1922 were of J.W. Wilburn and his son John Wilburn, charged with murder of the former mine guard John Gore, an event that initiated the fighting on Blair Mountain. Both were found guilty and sentenced to 11 years in prison, but were paroled in 1925. In August, the next and final trial heard at this courthouse was the treason trial of Walter Allen, head of the Dry Branch UMW local, who had led hundreds of miners from Raleigh County. In Blizzard's treason case, and this is interesting, in the first trial, the Judge Wood, had instructed the jury that unlawful assembly, even if it resulted in violence, did not constitute treason if the participants were not conspiring to levy war against the state. This time, however, Wood pretty much paved the way for a guilty verdict by instructing the jury that all the prosecution had to do was prove that Allen was present at the march. 2 witnesses, the minimum number of witnesses required for a treason charge, testified that they'd seen him among the marchers in Logan County. After deliberating for 48 minutes, the jury found Allen guilty of treason and recommended a prison sentence of 10 years. We don't know what prompted the judge to change his views, But the writer James M. Cain, who has been on Recent twice, had been covering the trial for the Baltimore Sun, and he wrote a scathing denunciation of it. Quote, "By a jury of his peers, packed against him and bearing instructions virtually proclaiming his guilt on the flimsiest sort of evidence, with not even a ghost of a chance at a fair trial from start to finish, Walter Allen, union miner, has been solemnly adjudged to be a traitor to that section of coal operators' real estate known as the sovereign state of West Virginia." End quote. Allen, however, did not have a retrial or serve any time because he escaped while out on bail and was never heard from again. Due to a flood of propaganda about the trials, which made it virtually impossible to find an impartial jury pool, the next treason trial, that of UMW District 17 leader Frank Keeney, was relocated to Logan County Courthouse, where his indictment was dismissed. Eventually, after 2 failed attempts to get guilty verdicts against Blizzard and Keeney on other charges, the prosecution dismissed all the remaining treason charges. In the end, the trials lasted over 2 years, costing the state upwards of $1 million in court costs alone. This also hurt the cause of organized labor in the state. The trials and the forfeited bond on Allen bankrupted District 17. This is especially problematic as many miners and their families remained on strike. While this was all happening, the strike was still ongoing, and they were living in the Lick Creek Tent Colony. To compound matters, the UMW cut off funds to District 17 after the trials, and Keeney was forced to end the 2-year strike. Faced with mounting pressure, Keeney and other district officers resigned their positions, and District 17 went into receivership. The trials of the West Virginia miners occurred in the midst of the struggling labor movement, which explains why so much attention was affixed to them. Although the March on Logan and the Battle of Blair Mountain were regional conflicts, they symbolized the fight for the right to unions to exist in the United States and workers' right to protest their conditions. While the miners may have won the legal battle, they ultimately lost the war, as the union closed shop in West Virginia in the aftermath of the trials. But the movement in the state and the country would be revived again during the surge of union organizing during the New Deal era. Now, just as an epilogue to an epilogue, there was another person whose career was upended by his participation in the events surrounding the West Virginia mine wars, specifically the 1920 to 1922 strike in Mingo. If you recall, there was a district judge who issued a legal decision siding with coal operators. The decision contained an injunction prohibiting union activity from the strike zone, which was a major win for coal operators. So this is the red jacket injunction that I had mentioned earlier. Now, fast forward to 1930. President Herbert Hoover had to fill a vacancy in the Supreme Court, and he announced Judge John J. Parker of the United States Court of Appeals for the Fourth Circuit as his nominee. Shortly thereafter, there was a flood of opposition, primarily coming from organized labor and their congressional allies, all based on his decision in the case United Mine Workers of America versus Red Jacket Consolidated Coal and Coke Company. Based on this one decision, and it's one injunction, it's really the injunction in this decision, and this decision alone, the pro-labor forces succeeded in defeating his confirmation. The mine wars and their legal aftermath are more relevant than just the fact that we are currently commemorating the centennial of the trials. They are relevant because of what's happening to the state of protest today. The thousands of miners and sympathizers who took up arms and joined the march to Mingo in the late summer of 1921 were the last in line of a decade of miners who had engaged in direct action, sometimes violent direct action, because they had no other recourse to protest their conditions. Local courts, law enforcement, and state officials did nothing to intervene as coal companies suppressed civil liberties, controlled their communities, paid them starvation wages, and threatened any union organizer. In fact, the legal and law enforcement systems were often used against them to further bolster the power of private companies. When they couldn't legally protest, there was no way to make their voices heard, so they took up guns and fought back. The right to protest is protected by the First and 14th Amendments. The practice of civil disobedience, while not a constitutional right, is also woven into the very fabric of our national civic heritage, especially when protesting unjust laws. For evidence of this, look to the collective actions of the civil rights movement. At different points during the mine wars, state and local officials denied miners the right to assemble in groups of more than 3, fearing that could turn to support for a union. By attempting to silence the miners who were working to unionize and their supporters, officials effectively denied them their right to free speech and free assembly. By seeking court injunctions preventing the miners from organizing within a strike zone, officials further denied them civil liberties and suppressed their ability to protest their conditions, because one of their main ways of protesting was to unionize. By charging the miners who marched with treason against the state of West Virginia and murder, while leaving the mine guard system in place and filing no charges on members of Don Chaffin's army, even those who dropped bombs from planes on the miners, the state further showed its willingness to protect the interests and rights of a particular segment of the West Virginia body politic, and not the whole. History does not repeat itself. Contexts are always changing. But certain ideas, trends, and types of actions can ebb and flow. Throughout the last century, periods of heightened, or at least very visible protests, have often been followed by swift legal and/or legislative backlash. Currently, we are in a period when state officials are debating and passing legislation targeting the right to protest. Legislators began introducing these bills in 2017. There was then a surge of anti-protest bills in the wake of the Keystone and Dakota Access Pipeline protests, and another surge in response to protests following the murder of George Floyd. In fact, 2021 saw the highest number of these bills being debated in state capitals around the country. While some of these laws target environmental activism specifically, and others focus on general protests, almost all of them portray protesters as being potential threats to public safety. According to critics of these laws, one major concern is that they engage in legal overbreadth, which means that more speech or conduct protected by the First Amendment is prohibited than that is necessary to achieve the government's interests. Another concern that critics raise is that these laws could have a chilling effect on the right to protest, essentially silencing protesters by creating an atmosphere of fear that their actions would subject them to legal or police action, even if they are acting peacefully. Breaking the law and destroying property, which most of these laws target, are already punishable offenses, but these laws now often make imminent danger rather than actual harm a punishable offense, according to the Center for Public Integrity. More often, they often give law enforcement much more discretion in targeting protesters and even determining who can use the proverbial public square to make their voices heard. The defenders of anti-protest laws argue that they are there to ensure that protests are peaceful and to prevent riots. But these laws could have a strong effect on determining what kinds of protests are considered legitimate and which ones aren't. Would this then generate the kinds of conditions that would lead to more drastic actions? What will happen among those voices that are silenced? What recourse, like the imprisoned miners in Mingo County in 1921, would they have? Historically, Americans, particularly marginalized citizens, have turned to direct action, including civil disobedience, when they could not find recourse in the legislative or legal processes. And when their voices were silenced, as they were in West Virginia in 1921, some turned to even more drastic and violent measures. Hopefully, a variation of this won't happen again 100 years later. Thank you. So both the prosecution and the defense went through some interesting measures to try to sway public opinion. The coal operators, because they had substantially more money, could get some big names. Like they had Billy Sunday, who's a very famous a preacher, kind of do a tour of West Virginia, drumming up support for them. And the miners, I think both sides, and this is according to Howard Lee, so this is the only account that I could find this in. But according to his account, both sides got voting lists and would go kind of door to door. So the people on the side of the United Mine Workers would pose as traveling sewing machine salesmen and try to drum up support that way. Again, this is from one particular source, but it does kind of speak to the fact that the jury pool was so tainted that's why Keeney's trial had to be moved from the Jefferson County Courthouse. And so that's why there are various trials around West Virginia associated with the mine wars. I just moved to Baltimore like 2 days ago. So, but my research right now is I was living in Charleston, South Carolina, and I'm working on another National Historic Landmark nomination for a factory that was the site of an important cigar factory, a strike from 1945 to 1946, and it's about how this particular strike really led to the downfall of or had consequences for Union activity during the Red Scare. and how the kind of failure of the CIO to organize the South after World War II.
How long did you teach at the College of Charleston?
7 years. Yeah. I do labor history and public history, and then decided that I wanted to go full-time into public history, so at a labor history museum. Well, actually, one of the things I think is interesting in bringing up Paint Creek, Cabin Creek strike, at the same time that that was going on, so that was 1912 to 1913. From 1913 to 1914, you have the famous coal wars in Colorado. This is where you have the Ludlow Massacre. And you do have Baldwin Felts agents going who had experience in West Virginia, going to Ludlow and kind of like having that connection back and forth. So those are happening concurrently. In terms of like the strike in Mingo, that another thing is happening concurrently, because there is a massive strike wave after World War I. Particularly hard hit was the steel industry, and so a lot of times if you read about like the kind of violence and the post World War I strike, most of the attention is focused on the steel industry. So, but this is happening kind of again at the same time. But the level of state suppression is not what it is like anywhere else as it is in West Virginia. Because like if you think about also Colorado, that involved Rockefeller, and Rockefeller made concessions and had this whole new kind of labor management model that he developed in the wake. But that again was more focused on private actions. What the focus on the attention in West Virginia is what the state was doing to actively support coal mining. So that's why like each one kind of has its own flavor, even as they're kind of operating concurrently. Oh, one other thing about this I meant to bring up before, again, talking about the things happening concurrently. If you look at the strikes in coal areas, whether it's bituminous, anthracite, it doesn't matter kind of where you are, all of them have a demand for their own check weighman. And that was because, of course, you got paid based on the ton or tonnage that you produced. And the miners wanted to make sure that they could elect their own person to weigh what they produced each day, not having somebody from the company, weigh and, ostensibly like undercut them. So that's why that is interesting that no matter where you are, that demand is common in every strike. The other thing that miners really struggled with, going back to the safety laws, they only got paid in what they produced in their tonnage. So all the work that was needed to shore up mines, putting up roofing, like hosing walls down, all of that, like all these safety measures were considered dead work, and they wouldn't get paid for that. So those were, again, kind of all these ways in which they were shortchanged out of the work they did. I don't feel qualified enough to really kind of, comment on contemporary circumstances, because I try to kind of make parallels. One of the things that I'm interested in following what's happening with Amazon is the level of surveillance. And this is not just Amazon. This is kind of like all industries, because of the technology that they can really see, timing it to like how much time someone would need to get from point A to point B, and how many, packages they produce. I mean, that's scientific management. That is something going back to Taylorism, late 19th, early 20th century, somebody with a stopwatch. There's actually another story about this is a textile strike in North Carolina, and I think it was in the Gastonia strike in 29, but double check me on that. But one of these strikes, they had a march and they had somebody in a coffin. And every so often, the person would pop out, and it's just like, how many people are carrying this? And they would answer like 6. It's like, cut 2, 4 can do the job. And so it's like, but it's like that type of thing is happening now, and again, has the focus now is especially on like the health consequences. And so I would be really curious to see what happens in terms of regulating that, if there is going to be some kind of regulation coming out on that kind of modern scientific management. Thank you. Thank you all for having me.